In the past week, several of my clients who are in deportation proceedings actually had their green cards approved by USCIS, and they are still in removal proceedings. So now that they are permanent residents, the next step is for me to file motions to terminate the removal proceedings since they are no longer deportable. And most immigration judges should pretty easily approve that motion to terminate removal proceedings. And then the next step is going to be to either remove conditions on their residency if they became a permanent resident through marriage to a US citizen and their marriage was fewer than 2 years old, or apply directly for naturalization once they meet the time requirements and become eligible for that. So a lot of happy stories in the past week, literally. For those of you who are still in removal proceedings and are arriving aliens, there is some hope that USCIS is going to start approving more of these in the future. At least that's what I've seen anecdotally with my cases. And some of these cases have been pending for like over a year. And by that I mean their interviews with USCIS were over a year ago. Within a week or two of the interview, USCIS approved the I-130, and then the I-485 just remained pending. And then we just got a series of approvals, which was really happy news because I wasn't exactly sure what was going to happen with these. Legally, USCIS should have been approving these all along, but I don't know exactly what caused these delays. I think they were waiting for guidance from DHS headquarters before they moved forward and made decisions on these. Now, the situation for arriving aliens, and by that I mean the notice to appear, the charging document that places you in removal proceedings, says you are an arriving alien. There are 3 boxes at the top of the NTA. One of them indicates you are an arriving alien, and that's usually when you've been placed into removal proceedings at a port of entry, or you've been paroled into the US and then receive a notice to appear simultaneously while you're being paroled. Those immigrants have unique options available to them because when you are an arriving alien, USCIS has exclusive jurisdiction over your I-485 application, so you can actually file the I-130 and I-485 concurrently with USCIS even though you're in removal proceedings. And I'm going to give you an example of a case I have pending and what the strategy is. But before I do, everyone who's not an arriving alien has to do it as a 2-step process, and they are the ones who are having major problems right now. So step 1 is you would file just an I-130 because USCIS is the only agency that has jurisdiction over an I-130. An immigration judge cannot make a decision on an I-130, but you need an I-130 approval if you're in removal proceedings and not an arriving alien so that you could file the I-485 with the immigration judge or file a motion to terminate for the judge to terminate removal proceedings. If they terminate removal proceedings, then USCIS will have jurisdiction over an I-485. If they do not terminate removal proceedings, you need an approved I-130, and then only the judge will have jurisdiction over the I-485, and you would need to file the I-485 directly with the immigration court. Not ideal, very expensive. For example, filing an I-485 with the immigration judge directly, you have to pay the normal fee of $1,440, but you also have to pay an additional $1,600 immigration court processing fee for that I-485. So just the legal fee for the government for the form is around $3,000, and that doesn't include the additional $10,000 you're going to pay for legal defense in this situation. So very expensive to do it in removal proceedings, much more cost effective to terminate the removal proceedings and then file the I-485 with USCIS. The big problem we see right now in certain jurisdictions like New York, or actually most of the United States where cases are beginning to move faster, is when you file a standalone I-130, it can take like 2 years on their current processing times to get an approval. There are people who filed these 18 months ago and it's still crickets. They haven't heard anything from USCIS. No interview has been scheduled. And the immigration court isn't going to wait for that I-130 to get approved. They will ask you to move forward on a defense from removal. And oftentimes, you don't have any other defense other than applying for adjustment of status. But without an approved I-130, there is no adjustment of status. And so you're stuck filing something like an application for asylum to just buy time. And I'm not saying a frivolous application for asylum. I'm saying an application that is honest, but probably unlikely to be approved. And that has its own challenges right now because the immigration courts are pre-terminating these, which means they won't even always schedule a final trial date on that. Some judges will, some judges won't. It's highly nuanced depending on which court in which jurisdiction and which specific judge you get. But if the judge doesn't schedule a final trial date and that trial date isn't far enough out to allow that I-130 to get approved, you won't have an opportunity to get it approved. And then you might be stuck applying for something like voluntary departure, having to leave the US, transfer the I-130 to a consulate abroad, possibly triggering a 10-year unlawful presence bar, and hoping that you could reunite with your spouse in the United States, assuming this is a spouse petition, assuming all those other options end up playing out favorably at the consulate abroad. So it's a pretty terrible situation to be in right now if you are not an arriving alien and you have an approvable I-130 from an immediate relative, like a spouse who's a US citizen. Now, one of the cases I have right now is an arriving alien married to a US citizen, and I'm going to explain what's happening in this case. So we filed an I-130 and I-485 and the other supporting documents like an affidavit of support, employment authorization, like a year ago. And the immigration judge scheduled us for court. He does have a viable asylum claim that he can actually win. It's not a super weak asylum claim. Like, there's actually a decent chance of success purely on an asylum claim. So we attended immigration court like a year ago, and the judge scheduled the final court date for August 2026. And so about 2 months ago, let's say it was June 2026, I'm beginning to get a little nervous because USCIS still has not scheduled an interview for the I-130 and I-485. Luckily, last month, they scheduled the interview, and the interview was just a couple days ago. And I was actually on vacation during this interview, so I had another attorney cover for me, and I gave the attorney 2 instructions that I said, look, there are 2 things you really need to push for at this interview. So this attorney was just substituting for me and appearing on my behalf. They submitted a notice of representation, substituting counsel for my presence, and they had 2 instructions for me. 1, ask the USCIS officer to make a decision on the I-130 petition as soon as possible, because without an approved I-130, we're not going to be able to push this final trial date that's scheduled for August back. If USCIS takes their sweet time and doesn't make any decision for 2 months, my client's going to need to move forward on an asylum claim, which, is winnable, but that's like a 50-50 shot at best with the current immigration policies. And the second instruction I gave was you need to tell the USCIS officer, if they try to administratively close this I-485, that the client is an arriving alien and USCIS has exclusive jurisdiction over the I-485. And I didn't think this was going to become a massive issue because most USCIS officers are pretty educated on these subjects. They've received training on it, but both things became a major issue during the interview. The interview started with the USCIS officer saying, we're going to need to administratively close this I-485 because we don't have jurisdiction. You're in removal proceedings. And the attorney pushed back super hard. And she said, no, he's an arriving alien. Here's proof that he's an arriving alien. Here's a memo that the attorney, me, prepared explaining that they're an arriving alien, you have exclusive jurisdiction, and you need to make a decision on this I-485. So the officer had to go back and forth with his supervisor like 3 times and said, you know what, it's our position that we don't have jurisdiction over this I-485, so we can't make a decision on this right now. And it got to a point where the attorney had sufficiently developed the record and said, we are going to appeal that decision. Please send this to your local counsel. So USCIS has their own counsel's office that gives them advisory opinions. To make a long story short, several hours after this interview, we got an email saying, we do have jurisdiction. USCIS admitted that we were correct and that they had made an error and that they're going to expeditiously schedule a second interview to make a decision on the I-485. More things happened during this interview, but for time's sake, I'm just summarizing. The second thing we asked them to do is to make an expeditious decision on the I-130. So regardless of whether or not they had jurisdiction over the I-485, which is the application for permanent residence, they certainly had, or are the only agency that had jurisdiction over the I-130 petition. And the USCIS officer gave us pushback on this as well. Quick side note, this is a super legit marriage, tons of evidence, easily approvable, but when you file an I-130, while you're in removal proceedings, you are subject to a heightened standard. We do need to submit additional documentation, but we had met our burden. And so the attorney who was representing my clients during this interview made that point abundantly clear multiple times. And the USCIS officer kept saying, I understand what your position is, but since they're in removal proceedings, I need to request a copy of the file from the immigration court first, which got me super nervous because if they're requesting a copy of the file, that could be weeks. And weeks can turn into 2 months, and we could end up going to the final trial date without an approved I-130, which would be a very weak position to be in. Anyway, my clients ended up leaving the interview. They were there for like 2 hours. They had to leave the interview and go back in after the USCIS officer spoke to a supervisor. This happened like 3 times. Eventually, they left. I spoke to the attorney over the phone because I was away, and I learned everything that happened, and I was pretty nervous about the outcome of this case. I'm like, oh no, if we don't get an approved I-130 approval, like we need to begin preparing super hard because this is going to turn into a full-blown asylum trial where I won't even be able to make arguments to show that they're married to a US citizen because we don't have an approved I-130. Luckily, a few hours later, we got an email saying that they are going to continue processing the I-485 because they have jurisdiction. And the following day, we got an I-130 approval notice. So whatever file that USCIS officer claimed they needed to get from the immigration court, I don't know what happened with that. I kind of doubt they got it that quickly, but they ended up approving the I-130. So now, let's take a step back. Before this I-130 got approved, I had submitted multiple motions to terminate these removal proceedings to the judge. I was pretty much harassing the court at this point, basically saying like, look, this person has adjustment of status pending, cancel this future court date. Please cancel it. And I did this multiple times. I did 3 motions to terminate. I did a motion to administratively close. I also did a motion to continue, which is like an adjournment request saying, give us more time. Look, this is pending. The regulations and current policies allow you to give us a little bit more time at least if we think that a final decision is going to be made within 6 months. The judge ended up denying all the motions to terminate and basically said, you don't have an approved I-130, my hands are tied. She then ended up denying the motion to administratively close and said, this is not an appropriate remedy under the circumstance. But she ultimately, just last week, right before we got this I-130 approval, did end up approving our motion to continue and gave us like another 2 months. Still not a ton of time. But right after she granted that motion to continue, we ended up getting this I-130 approval notice. So now, this week, I'm going to be preparing another motion to terminate saying like, look, you said you can't approve this because we don't have an approved I-130. You can't terminate the removal proceedings because we don't have an approved I-130. Now we have an approved I-130, so please reconsider. Hopefully this ends up getting the case terminated. If not, we at least have another few months for USCIS to make a decision on the I-485. They can approve it because my client's an arriving alien. Either I'm hoping it's going to get terminated or we're going to get an approval on the I-485, both of which would remedy the removal proceedings and allow my client to become a permanent resident. All right, guys, so I just wanted to share that story. This is a recent nightmare that I've been dealing with. I thought I would share my nightmare and make it your nightmare. If you're new to my channel and you want to stay up to date on all the recent changes under the Trump administration, you should subscribe. If there are specific topics you want me to address in future videos, throw them in the comment section below. I do read them before each round of filming, and I do use your input to create topics because I want to create videos and content that are beneficial for the immigrant population and people who are subscribed to the channel. If you need any assistance with a family-based immigration matter, I handle these cases nationwide. I focus on spouse petitions, petitions for parents, petitions for children, whether that's adjusting status in the US or abroad. And I also do removal of conditions, I-751, and naturalization. These are all I focus on day in, day out for over a decade. So if you want someone who doesn't dabble in different fields of law, a little bit of this, a little bit of that, just focuses day and night on one field of law and is laser focused on that, you could find the consultation link in the video description below to schedule a consultation. Or if you have any questions like how much does a case cost, what's the procedure, can you handle this type of case, just give my office a call. We would be happy to answer those questions to see if we're a good fit for you. Thanks for watching, and I'll see you next time for another video.